I'll read out only some parts of the judgment. Situated thus, it can be safely said that the petitioners herein are public servants in terms of the provision of Section 2C of the PC Act. This has also been observed by the Honorable Supreme Court in the case of State of Gujarat versus Mansukh Kanjibhai Shah, 2020, 20 SEC 360 at para 49 and 50. I'll not read out this. On a contention of the petitioners that the provisions of Chapter 8.27 of the CBI manual was given a go by the investigating officer, in that the contents of the source information have not been reduced in writing and thus procedural impropriety has been occasioned. Case of Vinay Narayan Supra being applicable. This court, on an overall analysis of the facts and circumstances of the case of the CBI made out against the petitioners, would opine that there are enough available materials, including documentary evidence, to conclude that a prima facie case has been made out against them. Thus, the source information has credence in this regard, irrespective of whether the same ought to be reduced in writing or not. We'll discuss about Section 482. Therefore, this court has no hesitation to conclude that the petitioners have not been able to make out a case in their favor, and for this court to exercise its inherent power under Section 482 CRPC. Accordingly, these petitions are found to be devoid of merit, and the same are accordingly dismissed. Hereby dismissed. Thank you. Yes.
Yeah, please, Lordship. I beg to mention item number 5, Lordship. Yes, Lordship, I pray for 2 weeks' time, Lordship.
You are for?
I am for the private respondents.
I'm for the petitioner.
327. Sorry for 1 and 2.
This is what is the issue here, Mr.
We had applied for mutation. That has been rejected by the cantonment.
And who are you?
I am for private respondents.
They're co-lessees in the same property.
Okay.
Leaseholders as well. Joint leaseholders.
So you should be on the same side, or
So
why
they
are
are
you
objecting to the mutation. They're also objecting to the mutation. I have acquired part of that property by way of a gift.
Are you related to them?
Not related. Not related.
How can you be co-lessee of a single
In
property?
cantonment, it's permitted, my lords. Multiple people can be co-lessees in the same property.
Okay.
Not
Moreover, Lordship,
Is it a apartment type of thing, or
No,
just
no, it's
for
a
the
land. It's a land. It's a plot of land. So there is an imperfect partition between them.
But it would be demarcated and properly.
Yes, not necessarily by way of a wall, but they have their own understanding, my lords. In certain areas, there is a demarcation. Certain properties, there is no demarcation. So that is.
So your land cannot be distinguished from his land.
I'm not really sure insofar as this particular property, how do they distinguish? But they have some sort of a virtual demarcation, my lord.
You see, if he is, I mean, if you have arrayed him as a respondent,
Lordship.
so it means that he is taking claim to the very same plot that you are also, interested.
Correct. But he's saying that my source, he's questioning my source. He's saying that the gift deed itself is illegal. That challenge should be made before the trial court, and they've already approached the trial
What
court.
is Lucas Sandai as far as that is concerned?
Their co-lessees, the original person who granted us the donor in the gift deed, they claim that the donor, as per Mohammedan law, did not have the power to make that grant, to make the gift. It is not permissible under the personal law.
But why come by way of a writ?
Because we are questioning the order of the cantonment in refusing the grant of the mutation. Because in other cases, they have allowed the mutation despite the pendency of a dispute. In our case, they say there is a dispute, some objection has been raised by co-lessee, so therefore we cannot grant it. That is arbitrary because in other plots of land, they've allowed it.
There is no separate mechanism for, making such claim, or Cantonment Act, what does it say?
Look, as far as the question of dispute, it doesn't really say anything. When somebody makes an application for a mutation, they issue a published notification inviting objections. So anybody who has an objection may appear before the cantonment authorities and raise whatever objection there may be. Now, in this particular case, the objection is with regard to the title, my source of acquiring the property. Now, that is a subject matter to be decided by the civil court. I have a registered deed in my favor. So rightly now, after I file this writ petition, the private respondents have approached the civil court.
But the property belongs to this cantonment, isn't it?
Yes, my lord. So they grant leases to different people, and I'm actually residing in the property. It's not that I'm not in occupation. I am in occupation of the property.
You're saying something about Mohammedan law and all these things.
Yes, my lord. What's happened, the person who originally owned the entire property, he granted some amount of area to a third party, that is my father, by way of a gift deed. Now, the private respondents who are the descendants, they are challenging that particular grant. They say that under Mohammedan law, a Muslim cannot make a will of this, cannot gift beyond a certain amount of his property. So that is the challenge.
Oh, so that would be a civil dispute.
Yes, and they have rightly gone to the civil court now.
Already filed civil.
Which, and we have raised an objection there that is a time barred issue.
Anyway, since you are not prepared today, it would be interesting.
All right, next week we can dispose of this.
Yes, my lord.
Pleadings are complete.
Yes, yes.
All this is for hearing.
Outcome.
You have a respondent?
Respond number 327.
327. Mr. SP SD Upadhyay, Learned Counsel for the respondent 327 respectively, has sought for accommodation on grounds of personal difficulty. The same not be objected to by the parties present. Prayers allowed. This is matter of 2 weeks.
Highly pleasure.
Lucy, I beg to mention item number 3, Lucy.
Worship, respondent 4 and 5, they are yet to enter appearance. We have
Have you
received
taken steps?
information. Yeah, we have already taken steps. We have received information that they have received the petition.
Have you filed the affidavit of service?
Not yet, Worship.
Let the matter be called up. Let the matter be called up. We'll see.
Yes.
If it is on that aspect, then an order can be passed.
Well, please, Lordship, I beg to mention item number 4, Lordship. I am praying for 1 week time.
Is that school teacher matter?
Yes, Lordship. Termination of the petitioner, Lordship.
Because of the participation in the election? So since when she is out of she was out of service?
2018, Lordship.
Not 2020.
2020, Lordship.
2020.
January 20.
In her place, somebody has been appointed.
That is, Your Lordship, I am not here because Mr. KP is appearing for the government. Whether
You are appearing for whom?
I am for the managing committee, president and
Then you
secretary.
should know.
But
You are a managing committee. You should know if
Yes,
you
Your
see,
Lordship, I'll
if it is a case of termination.
yes, Your Lordship.
Suppose the petitioner has been terminated. So eventually, see, you have to fill up that vacancy.
Yes, Your Lordship, I seek instruction
So
regarding
whether
this.
that vacancy has been filled up, how it was done, whether they have arrayed the, because once the vacancy is filled up by somebody, then that person, has acquired a right.
Yes, Your Lordship.
So he or she has to be
But
heard.
only thing is that, Your Lordship, my learned friend has not annexed the termination order also. Termination order is not there in the writ petition. Only one release initially before inquiry and issuance of notice. One release order was issued by the school authority managing committee. That release order is only annexed in the prayer part, Your Lordship. But this release order is not final, Your Lordship. Thereafter, 2 notices were sent to the petitioner, but it was not received by them. Then she participated in the inquiry conducted by the government. But thereafter, release order issued, termination order issued by the managing committee, and it is approved by the government also.
But have you annexed that in your affidavit?
Yes, these things, because last November, Your Lordship was pleased to allow me to file the affidavit, so I brought it. But in this regard, whether this page and that post is filled up or not, that is, Your Lordship, I am not here. I will seek instruction, Your Lordship.
On premium by the parties, let's this matter after 3 weeks.
Major.
My lord, I beg to mention item number 2, my lord. I need some more time to prepare the matter, my lord. Is that those Nehu matters, my lord?
So nothing is left.
My lord,
Nothing is left for this court to sit for the day. On premium by the petitioner, have you sought the consent of the respondent?
I was looking for them, but no one is there, my lord. I'll
What
just
if they-
inform them, my lord.
What if they vehemently object?
My lord.
On premium by the petitioner, this is matter after 2 weeks. But you see, in such a case, it is incumbent upon you
My lord, my lord.
to inform them beforehand. You see, you can always make a call.
My lord.
They are all your colleagues.
But I was under the impression that the junior should be there.
Don't take things for granted.
My lord. I'll inform them, my lord.
Now, you see, order has been passed. Even if they grieve, they'll have to come by way of a petition to vacate this order.
My lord.
Daily list item number 1.
Lordship, in this matter, only respondent number 9 had filed the counter affidavit. Other respondent haven't filed till now.
Your Lordship, just we got the copy and send this one. It will take time, Your Lordship.
You are appearing for?
I'm for the responder 1 and 2.
What is this matter about, miss?
This is the border fencing, Your Lordship.
Border fencing. Is it, in respect of compensation, land compensation?
No, they are asking about the alignment of the border area and not to this that.
Lineman?
Alignment of the border, from the this area of the boundaries of this individual, then they are saying that to reduce the area, and we are saying it is not possible as a government of India because 150 yard will be there and we cannot reduce, and they are saying this to reduce. So this is the issue.
So is there any notification or regulation or
This is the Geneva
guideline?
Convention. Geneva Convention is there with this.
Geneva Convention, yeah.
It is there. It is not only this only for Meghalaya, but it is
You have
all
annexed,
over.
you have annexed that with your
So you will see,
counter?
we'll be filing this one by affidavit. It will take time because we got the copy just last week. I sent it.
So you have not filed your counter?
No.
The other respondents?
Petitioner has annexed some documents and some notes regarding the India-Bangladesh treaties.
What is your role?
Lordship, in this matter, Lordship, the soldier had asked whether the KJC had issued notice or had issued NOCs to the government for acquiring the land. So that's the only, as per my knowledge, that's a
The land is a private land or right land? It's a right land. Then how is the petitioner involved here? Any of his land?
As per his contention, Lordship, he is the soldier.
Or he's a sorra?
As per his contention. Because as per documents which are next, there was a earlier soldier who had approved the building of it. Lordship, I keep all this in my affidavit, Lordship.
In that case, you have to prove that such an OC was really sought from you by the concerned authority, and whether there are correspondence between you and the soldier, either the erstwhile or the present soldier.
The government files the affidavit, Lordship.
Mr. R. Devnath, Learned Counsel, Learned CGC, appearing for the respondent number 1 and 2, has sought for time to file the counter affidavit. on the ground that the copy of the petition has been received only recently.
Lordship, we have supplied the copies on 28th March 2024, Lordship, to the.
So for him, you see, between March and May, it's only a short time. He needs at least 1 year to prior notice, and then he will file the affidavit after 2 years.
Come from
Do that.
ministry, at least
You
6
see,
to
Mr.
8 weeks
Devnath,
will require.
whenever you get these things, you immediately take steps for getting specific instruction or otherwise comment or whatever, and do it. I've noticed that in this court, more often than not, the union would always be very slow in filing.
Earlier it was there.
Only on the ground of seeking instruction.
Earlier, you see, ministry used to have we sent to ministry straightway and come late. So now when notifications come up, last occasion when I went in Delhi some matters, then I tell this it is too tough for us because we are having the communication. It is 3 months, 4 months like that. So now Government of India has given border security force. They will be the nodal officer here.
Okay.
So now I am corresponding. So I have sent the copy on 21/5/2024 only to them because as per this notification through this BSF.
Anyway, you do whatever is necessary.
Absolutely.
If it comes to a pass that things have taken very
We'll try to-
inordinate delay, then the court will summon the
And
official
this
concern.
true.
All the other respondents have not filed.
Your Lordship, appear for respondent, I filed my.
You have filed. Next, except for respondent number 9, the other respondent have not yet filed their counter, and similar prayer have been made by the learned counsel of such respondents, seeking time for filing the counter affidavit. On prayer made, the counter affidavit is directed to be filed within the next date fix. Is this matter after 2 weeks? 3 weeks. That'll give you enough time.
Item number 3.
Okay, so the reports have not yet come.
We haven't received yet the status report from post office,
So what do
but we have received oral instruction from the parties when that the respondent 4 and 5 have received the copies.
just a moment. You see, in this kind of a situation, you should go through the case record. Whenever the case comes up, or even before that, you should go through the case record and find out. Because what happens is, as far as notices are concerned, the parties will take step, but the process would actually be initiated by the registry. So any correspondent would not be directed to you, rather to the party. It would come directly to the registry. In this case, the office note would show that the AD card has returned, which means that effectively the notice have been served. So only on the basis of the AD card you could file an affidavit of service, but this is not in your possession. What you do, what you do is you go through you should. I'm not saying only in this case. You should go through the record. If such a case, if suppose like this case where the AD card has come. You go through the record, produce the AD card, and file an affidavit saying that the notice is deemed to have been served since it is reliably learned by the petitioner that the AD card have been returned to the registry. That can be always verified. It is not a question of, that is in the air or something. You could do that and the court will accept it.
So much.
Mr. Learned Counsel for the petitioner has submitted that it is reliably learned that the notice issued upon the respondents number 4 and 5 have been received. However, it is prayed that some time may be allowed for the affidavit of service to be filed. On pre-made, the same is allowed. Let the affidavit of service be filed within the next date fix. List this matter up to 1 week.
New pledge.
Item number 6.
I humbly pray for adjournment, Your Lordship, in this matter, as the conducting counsel is on legs, Your Lordship.
Yeah, well, Mrs. Sen was here a while ago. Yeah, Mr. Karolang is here.
I ask for adjournment. Ask for adjournment.
Okay. Okay, so there are about 4 respondents. You are appearing for?
I'm for respondent number 1, Your Lordship.
Number 1. And you? 2. Who was appearing for 3 and 4?
Senior counsel.
Oh. The junior colleagues are not here.
No, Lordship.
Mr. Karolang?
Objections, Lordship. Lordship, Lordship,
Go ahead. You start.
Lordship, I've been informed by the council that it won't be doing today, Lordship. So even the conducting council also didn't go through the file. Lordship, if I may suggest, Lordship, if the matter may be kept on fixed date, Lordship will prepare the matters and matters may not be adjourned on that fixed date, Lordship.
See, what happened is the court would pass an order, the matter to be fixed either after a week or 2 weeks or so, but the court master would have a list of dates.
Lordship.
You can always inquire what is the likely date where the case is fixed, when the case is rather listed. Otherwise, fixed date may not, sometimes you see on a particular date there may be too many matters or not many matters as like today.
Lordship.
So unless the parties agree to a particular date which is convenient to them, then it becomes.
If Your Lordship can have any.
But if you want, so you can suggest a date.
But Lordship, we have the matter, I think so, has been dragged on for some time. If a fixed date may be kept, Lordship will come prepared and we won't seek adjournments.
Yes, miss. When do we have it? Oh, but I'm told, rather it has been submitted by Mr. Dingro himself. Last time when he appeared, that he will not be stationed for about a month or so. He had gone for his medical treatment.
Lordship.
After 3 weeks, Your Lordship.
On pre-made by the parties, this is matter of 3 weeks. So we'll see on the next date. Please ensure that.
Lordship, even the leading counsel has been telling me that he keeps preparing the matter, but matter keeps getting adjourned. So
now he is not prepared today, and so
No, Lordship, we were actually, Lordship, yesterday and today both the CRP 1136, Lordship. So we were informed by the correspondent council that they won't be doing it, Lordship. Hence,
I think as far as Mr. Degro is concerned, that impression has been given to the court.
Lordship.
Of course, arrangement could have been made, but his junior colleague is also not here.
Lordship.
Fine.
I know, Lordship.